Hello, John Dove here from Speed Mooting. Welcome to the latest episode of the Speed Mooting Partners in Crime podcast. This is episode 30 of the Partners in Crime podcast. Yes, we have recorded 30 episodes now. Today was a fun episode. We dispelled another myth about the criminal bar, and today we dealt with that question that every criminal barrister deals with. How do you defend somebody you know is guilty? Hayley spoke about civil procedure, so from when you first look to deal with a claim all the way through to trial. We spoke about the Advocacy Club and what we have coming up in October, and our upcoming bail application competition in December, and the fact that all places are nearly filled. And we had a good discussion about a post I shared recently. It was a simple post, and I just simply wanted to say that I was proud of the fact that I finally made it to the bar after 11 years. Little did I know that would go viral. So thank you for the well wishes, thank you for the nice comments, and we spoke about that in a little more detail on the podcast. So we enjoyed recording the episode. We hope you enjoy listening. Welcome to the podcast. We are live. Welcome back, everyone.
Hi, everyone.
Welcome to the Partners in Crime podcast. I'm John.
And I'm Hayley.
Feels like this is the first proper episode we've done for a while, doesn't it?
Yeah, we've been go and juggling a million things. It's the first calm week that we've had in months.
It literally is, isn't it? Because we've had all the events on. Obviously, we had the episode while we were on holiday.
That was a good one.
That was a good one, wasn't it? Yeah. Welcome to the podcast. If it's your first time listening, Hayley and I, we are both lawyers. I'm a barrister.
And I'm a commercial solicitor.
And we talk about law. We talk about what we do here at Speed Mooting, which is a lot.
Yep.
So we run regular mooting and advocacy competitions. We have a monthly advocacy club that allows people to practice advocacy. We run lots of events, including a pupillage fair. And we do a lot of online events as well. So we do lots here at Speed Mooting to help the next generation come through.
Yep.
You know, we're both first generation university entrants, and we're doing all that we can to level the playing field for people. So we talk about what we do here at Speed Mooting. We talk about general things that we get up to outside of Speed Mooting.
Yep.
It does take up a lot of our lives, but we enjoy it, we love it, so who cares? And sometimes talk about other random things that might come up. So we hope you enjoy listening to the podcast. We hope you enjoy our conversations anyway.
Yep. And a big part of what we do and what drives the content that we bring to you on these podcasts is your questions, your feedback. So keep sending it in to us. We get lots of emails. If you'd like to email us, it's info@speedmooting.com. We also get lots of direct messages on LinkedIn, Instagram, and we get comments on our posts as well. And we do go through everything.
We do.
Sometimes slower than other times, depending on how busy we are. But rest assured, we see all your messages, all of your questions, and we will always answer them, usually on the podcast, anonymously, of course. Yeah. So keep engaging with us. We love to see it.
Definitely. So it's now time to name the episode. And every episode is named after an athlete with a corresponding number to the episode number.
Yep.
Generally speaking, it's Formula One drivers. If it can't be Formula One drivers, we'll look to other sports.
So the reason it's usually Formula One related, if you're just tuning in, is because John is an avid Formula One fan and also a little bit of a racer yourself.
I certainly am. Yeah. Do bits and bobs of racing, like the cars as well.
You do like your cars? Although you've got a 06 Astra?
08. Oh, wait, it's 2 years newer than that.
Sorry, God forgive me, yeah. Big difference.
Yeah, 2008, so 16 years old with 160,000 miles on the clock and runs as well as it did back in 2008. But, I've been talking for a while, haven't we, about getting a new one. And
yeah, it's coming soon.
It's coming soon. And I still keep flip-flopping about what I'm going for.
Yep.
So who knows what it's going to be next.
When we know, you'll know.
Yeah. I'm back on BMW again. I mean, you can't beat a BMW unless you're going for some sort of supercar. nothing drives like a BMW. You know, they call it the ultimate driving machine for a reason.
Yeah.
So I am back on BMWs again, but who knows, when I actually buy the car, I'll be able to confirm. But yeah, I flip-flop.
I seen a funny meme the other day. You think your job is like a waste of time or a waste of space, just think there's someone out there whose responsibility it is to put indicators on BMWs.
I saw that.
To be fair, though, they're not all bad drivers. Yourself included, you're a good driver.
Yeah, I think kind of the stereotypical BMW driver, I think they switched to Audis kind of about 10, 15 years ago.
Oh,
yeah.
right, okay.
Yeah, it's the kind of people that, the ones that kind of don't indicate, can't use lanes properly on a motorway, tailgate, all that kind of business.
That would make sense, because I used to have a Fiesta and now we've swapped to an Audi TT, and I think people are meaner to me, like, in the TT. Like, people, like, don't let me in as much, if I'm indicating to come in, or they'll try to cut me up a lot more and stuff. When it was just me driving my little fizz bomb, I think they must, like, see this red sports car and be like, ugh.
It's a jealousy thing, isn't it?
Yeah, they must, so they expect me to be a bad driver, or they just don't like me in the car.
Yeah, I think it's an element of that, isn't it? Yeah.
Anyway, we digress.
We're digressing. We need to name the episode, right?
We do need to name the episode.
So going back to it. So it's episode 30, so we need number 30.
Yep.
So we use the current numbering system, so drivers that have used these numbers since 2014. It's number 30. Do you know who it is, Hayley?
Is it a current driver?
Well, funnily enough, this week we've got two options because the number's been used twice, and this person is a very, very current driver in the sense that he made his return to Formula One yesterday.
Oh no, I didn't watch the race.
You missed the classic. Let me tell you, Texas has got possibly the best Grand Prix circuit because it promotes the best racing.
I was in the cinema watching Smile 2 instead. And it was terrifying, by the way. Any horror fans out there, it was scary. I spent a good, at least a third of that movie under the blanket, because I always take a blanket to the pictures because it's cold. So I hid for a lot of it. But anyway, someone who's just come back to Formula One. Is it the blonde guy?
It's the blonde guy.
I did see something on Instagram, because didn't he got points or something?
Yeah, he scored points yesterday, yeah.
But his name, I haven't got it in my brain.
It's Liam Lawson.
Liam Lawson.
Okay.
Oh, Lawson, it's so topical as well.
Isn't it just? Yeah, he's got law in his name. And the other chap that used it previously was Jolyon Palmer. A little bit before your time. I always come back to this, he's pre sort of Drive to Survive, so the Netflix gang probably don't know him either.
Right.
Yeah, he was in it for a couple of years, drove for Renault, and then obviously you got Liam Lawson driving for, what's the name of the team now? It's V-Carb, isn't it? Visa Cash App Racing Bulls.
Oh yeah, we went through that last.
Because there was a meme about this, because Fernando Alonso was complaining about him on the radio this weekend.
Yeah. And
he goes, the guy in the AlphaTauri needs to drive better, or whatever it was, and they're not called AlphaTauri anymore. So the V-Carb team put a thing on Instagram showing a photo of the two of them together, Lawson and Alonso, and he goes, just a V-Carb driver and a Racing Point F1 driver having a chat, basically taking the mick because Alonso's at Aston Martin, which used to be called Racing Point.
Right.
Anyway, I think we might be boring the listeners. We've spoken about cars, Formula One, motorway discipline, all the rest of it too much. Although motorway discipline is something I'm going to come back to at some point on a future episode.
Okay.
Maybe even today, I don't know. It's something I think I need to educate the country on. But we'll come back to it at some point.
Yeah, maybe let's put a pin in that one.
Yeah, let's put a pin in that one for now. Let's move on to what the podcast is actually about. What should we talk about, Hayley?
You need to do your line first. Welcome to episode 30.
Oh, sorry, yeah. Welcome to episode 30, the Jolyon Palmer and Liam Lawson episode.
Welcome. So first thing on the agenda, John, is just to give our listeners, our viewers, a little recap of our next competition.
Okay.
Because it is fast approaching.
It certainly is.
And of course we're talking about the bail application competition.
We certainly are.
Which is taking place online on the 7th of December. Now, places are filling up very, very quickly.
They certainly are.
Last time I looked, we were over 2/3. So
right.
I think maybe October they're all going to go. Potentially beginning of November. But if I were you, I would not wait.
I wouldn't wait. I would say if you're lucky, you might still get places by the end of the first week in November. If you're lucky, the way that our places in our competitions fill up. If you remember last time, we sent an email about the national speed moot saying like 85% of places gone, and they filled that day.
Yes.
And then we were getting people coming to us, I was thinking about signing up for that, but I wasn't sure. And at one time I was putting it off and it's like, well,
it's always there. It's a shame, isn't it? But
you snooze, you lose.
You do snooze and you do lose.
It's first come, first serve. We don't discriminate. There's no applications or any of that with our competitions. It's not. That's the whole idea of our competitions. They're for anyone to take part. You haven't got to wait for your university to put you forward. Your bar sizes. You go, you've done a few bits and bobs. I'll put you forward. No, none of that business. If you want to come, first serve. Get your name in the hat and enter yourself for the competition.
Yes.
So this is the bail application competition.
Mm-hmm.
For those that don't know, a bail application is an application made in court by a barrister or solicitor during the course of proceedings. So you've got a trial date, you're waiting for trial, and you're seeking to get your client out on bail whilst they await their trial date.
Yeah.
So that's in simple terms, that's it. You're trying to get your client out on bail.
Yeah.
So in terms of the format for the competition, the bundle is released the night before, so it's like life in practice, because on a bail application you're always going to receive sort of late notice, particularly if you're counsel. The number of times that my clerks ring me up at 9 o'clock, we've had a late return coming, do you fancy covering this bail up? Yeah, why not, let's do it. So it's like life in practice. We keep the bundles nice and short as well, because we know how busy you are, and particularly we have a lot of undergrads that take part in the competition who've maybe never studied criminal litigation, don't understand the procedures, etc. So the bundles are short and we give full detailed instructions as to what's required, what the law is, etc. The format for the day, we've got 200 competitors. We break you off into 20 groups of 10, and each group has their own specific set of judges, so either one judge or a panel of judges. One by one within your group, you will each perform to that judge, and the judge will decide the winner from that group. So we've 20 groups and therefore 20 winners in the morning. They will then proceed through to round 2 in the early afternoon, whereby we will have 5 groups of 4. Mm-hmm. Same again, each of those 5 groups have their own judge or judges. Each of the 4 within those groups perform to the judge, and the judge decides the winner. You've then got 5 winners who will face off against each other in the same format in the afternoon. The winner is going to walk away with an iPad. The runner-up will receive a £100 Amazon voucher.
Very exciting.
It is exciting. As we say, the competition is judged by practitioners. So we've got barristers, solicitors, we have actual judges.
We do. We're heavy into recruitment right now, and we've already had a few judges sign up, a few silks as well.
A few silks. So we've got top quality judges. Yeah. And not only are they there to judge you, they also give feedback as well. So after each performance that you do, you will receive feedback from the judge talking about what went well and what can be improved. So it's definitely a worthwhile day, isn't it, Hayley?
Oh, it's brilliant, yeah. It's a great way to boost your CV. It's a great way to spend your Saturday, and you can network with like-minded individuals.
Oh, of course.
So people make connections through our competitions and then carry them with them throughout the career. Yeah. And we spoke about networking a lot on last week's episode, so we won't go into that again. No. But just to stress, how important and useful it is. So, yep, networking is a really good opportunity that we provide.
It's crucial, isn't it? Mm-hmm. Yeah. So we hope you enjoy.
It'll be here before we know it.
It'll be here before we know it.
Is it about 6 weeks away?
Probably is. Yeah, 6 weeks there or thereabouts, and we run it from this very table.
So, just a little fun segment. Mm-hmm. When we ended last week's podcast, we teased that we had a fun night out planned. Yeah. We said we were going to tell people on this week's episode what it was. Okay. So, we went to Oktoberfest.
We did indeed.
So, for anyone that doesn't... I mean, I didn't really know what it was or what to expect, but it's like a German-style beer festival.
Pretty much,
Is that fair? So you've got the bratwurst sausages, the pretzels, the steins. I'll put the pictures up because the steins, the beer was bigger than my head, wasn't it?
It literally was.
It was bigger than my head, so it was really, really fun. I must say it wasn't as well attended.
No.
as we were expecting.
It was better than it could have been, though, because so my mate works in security in this particular arena, and I sent a message to our group chat saying, anyone want to come? And my mate who works there said, oh, by the way, we've sold 5 tickets and you've bought 2 of them, Dovey. And we're like, okay. And then we got there, and it was funny, there was a group behind us walking in, and they must have heard the same thing as well. They were joking about it. But there were a few people there, so it wasn't empty.
No, it wasn't empty. We still had a great night. Everyone was still up dancing, and it was really fun. It's just a shame that it wasn't full, because it was a really
good event. Yeah. It was a really good event. It's such a shame, and I do hope they bring it back, because
me too. And
the organisers have put a lot of effort in there.
Yes.
It was a good little night, so it's just a shame more people weren't there.
So we just need to shout about it a little bit more.
Yeah. Give them some promotion. Maybe we'll partner with them as well.
Yeah, we'll collaborate.
We can have an Oktoberfest stand at the Pupillage Fair next year. Oh, imagine that. Not giving any ideas away to the other Pupillage Fairs, but imagine if we have a beer and bratwurst stand.
That would be amazing. Yeah.
That'll get people through the door.
It would, yeah. Not that we need it.
Not that we need it. No.
So yeah, that's what we got up to on the Friday. So just wanted to let people know, in case they've been wondering about it.
People will be thinking. People have been spending the weekend going, "What is it that John and Hayley have done this weekend?" And
so now you know.
They'll know.
So something we were talking about last week, John. You were talking about your 12 months at the criminal bar and how much you're enjoying it, and you posted a little social media post about this, didn't you?
I certainly did. So I did a little post on LinkedIn, just a little. I didn't really think much about it. I just thought I'd say, it's been 12 months at the bar. I thought I needed to commemorate it by doing a little post. And basically I said, I finished the bar course back in 2012, and therefore it took me 11 years, well actually a little over 11 years, to finally make it as a practicing barrister. I spoke about everything that I did in the intervening period to build my CV and build the skills I needed to be a barrister. Spoke a little bit about how the past year has gone. So, I think the past year has gone pretty well, to be fair, because, I've really utilised my experience in road traffic law, so I've done lots of motoring cases, and also built up a very busy Crown Court practice as well, conducted lots of trials, won a number of jury trials, I must say.
Yep.
And also talk, generally about the kind of work I've been exposed to, which has been quite varied. I've been on large-scale conspiracies, I've been on a fair bit of Razzo work, a lot of violence, dishonesty, drugs, etc. So, and I kind of finished the post by saying, if you're out there and you're struggling, which a lot of people are, it's the numbers are against everyone. Because certainly from when I was trying to become a barrister, I think it was for every 5 people that do the bar course, 1 will get a pupillage. So if you did the bar course, you had a 20% chance of getting a pupillage. It might be worse now, I don't know, I've not looked at the stats recently. But regardless, there's many more places on the bar course than there are pupillages. So, it's a difficult thing, and people can become disillusioned, disenfranchised, they can, get down basically thinking, am I ever going to make it? And the point of the post, I finished by saying, look, if you've got that goal, if that's your desire, go for it, continue working and you'll make it. And that's basically what I did. I crawled, I kept working, and I knew what the goal was, and it meant, it took me over a decade. Hopefully it takes most people less than that. But the point is, it's not one of these where I thought, oh, do you know what, a couple of years I've not made it. If you really want it, don't give up, keep going for it, and you'll get there. You'll find a way, and that's what I did. I wasn't going to let anyone say no to me, basically.
Yeah. And it's obviously something that resonated with a lot of people.
Well, it certainly did, because we did this post, and I thought, I'm not one of these people who looks for likes or anything. And by chance, I was back on LinkedIn a few minutes later, and within 5 minutes, it's like 50 odd likes. I'm like, so this was, maybe 48 hours ago we posted this. It's over 1,700 likes, Hayley.
Yeah.
1,700 people. I mean, thank you very much for the support. And, I think over 100 and odd comments, and a lot of it are people saying, very inspirational, you've inspired me, I'm struggling with, looking for the motivation, etc. So I'm glad that it's had that desired impact, and people are looking at it and going, do you know what? There is a way I can make it. So I've gone viral, as the kids say.
You have gone viral. viral, yeah. Even more viral than you already were.
If you can imagine. I think like when you look at the impressions as well, it's like 50,000 people.
Yeah.
I mean, imagine that's like more than, well, I don't know if it's more than, but it's like having a football stadium of people who've seen a post about me going to the bar.
Yeah. Well done. Yeah. So watch this space, watch Sean's LinkedIn. I'm sure he'll post more now that he's so popular.
Yeah, I'm Mr. Influencer. I'll do some posts now. So if you didn't see enough of my face on these little clips you see on the Speed Mooting page and the Advocacy Club page and all the rest of it, watch out for my personal page as well now.
Yep. So when we were talking about the 12 months of the criminal bar last week, John, one thing you were talking about was the incorrect impression that lots of law students have that life at the criminal bar is going to be poorly paid.
Yeah.
So we kind of debunked a bit of a myth there, and I quite liked that. So I thought let's carry on. Let's make this a little segment over the next few weeks.
Yeah.
So the myth that I want you to debunk today is what people always say to you. Oh, but how do you do it? You have to defend people when you know they're guilty.
Yeah.
So let's talk about it.
Let's talk about that one. So that's one that you often get when you get non-lawyers speak to you about being a criminal barrister. And also a lot of students, you know, the question's framed slightly differently from students, but it's the same thing. You know, at the pupillage fair, I had a few people ask me, how do you deal with the morality of it? And so the answer is, so how do you defend someone who you know is guilty? And the general answer is you don't.
Yes.
Okay. So we have what's called the Code of Conduct, which governs the way we operate as barristers. We have ethical guidelines by which we need to operate. Now, let's take the classic example that somebody's thinking of, because a lot of people, non-lawyers, think that as criminal defence barristers, we are guns for hire. Someone comes in, tells us what to do, and we'll do anything that we can to defend them. And the reality is that's not what we do in any way whatsoever. So the classic example someone's thinking of is somebody's committed an offence. They'll come to you as the barrister. They'll say, yeah, I did this, but what I'm thinking I'm going to say is I didn't do it because this, that and the other. So can you put that case forward for me? If someone says that, you're professionally embarrassed. You cannot do that. So if somebody comes in and says, I did it, but I want you to say this.
No, you can't mislead the court.
You cannot mislead the court. Okay, so you snoop it there. You can't do that. You can't actively lie to the court. Now, somebody comes to you and admits to, so let's say you're in conference with a client, they admit to an offence. You've got a couple of options really. Firstly, you probably advise them to plead guilty because they're guilty of the offence.
Yep.
If they're adamant that they don't want to plead guilty, they want to challenge it, they want to plead not guilty, they want to run it all the way through to trial, well, you've got a couple of options. Firstly, you may be professionally embarrassed if they're wanting you to run contrary instructions. So if they're saying to you, I didn't do it, but I want you to say to the court, I did it, but I want you to tell the court I didn't do it, etc. Well, you can't do that. The one way in which you could remain instructed is if you were to effectively put the prosecution to proof. Okay. Now, it's not really the best course of conduct to do that because you're effectively then running the trial with one hand tied behind your back. Number one, you can't put your client in the witness box, because if questions are put to them in cross-examination and they start denying the offence, well, you're then professionally embarrassed. You can't then continue to run the case. Likewise, when you're cross-examining prosecution witnesses, you can't really put a positive case to them in cross-examination. You can only test the prosecution's evidence.
Yeah.
Okay. So your cross-examination is very limited. And then following on from that, your closing speech is going to be very, very limited as well, because once again, you wouldn't really be putting a positive case about your client not committing that offence. You're effectively just saying to the court, well, can you be sure? Okay. So realistically, you know, you'd be withdrawing if your client's giving you contrary instructions like that.
Yeah, I can't imagine there's great levels of success when you have to do that, because surely the jury, the tribunal must realise, why isn't this guy putting forward any defence? All he's doing is, as you say, testing the prosecution's evidence. I bet most people realise.
Yeah, I think so, yeah. I think if it goes that far, I mean, sometimes you might have it where you might strike lucky and you might be able to run a half-time submission, which is whereby, so let's say the prosecution have presented their case, all the witnesses are given evidence, you get to half-time, and you would, obviously this is a submission to the judge, and you would be saying, well, if you take the prosecution's case at its highest, no jury would actually convict on that evidence.
Yeah.
Then, you might get home on that. But once again, as you say, the jury's always going to have in the back of their mind why is this person not gone in the witness box? So they've obviously got that question lingering there. And I think stemming on from that, the other thing that a lot of people ask is, well, what about even if your client gives you instructions that they're not guilty, what about if you think they're guilty? Mm-hmm. Well, quite frankly, I'm not there to think about whether my client did or didn't do something. If my client gives me instructions, they're the instructions I'm running.
Yeah.
As in, so these are instructions that are consistent throughout. So they've never admitted guilt. They've come to you and from day one they've said, I didn't do this, I am not guilty. Well, they're your client's instructions. Why do I need to think about whether or not they've done that? I think that impedes your ability to do the job.
Yeah, definitely.
There may well be people that think about that, but my job is to present the case. Now, of course, there might be strong evidence against your client. There might be factors that weigh against your client, and of course, you'll give your client that advice. Particularly if you think the prospects are limited. Mm-hmm. If you think the prosecution's got a particularly strong case, you'll give your client that advice. But you wouldn't be, quite frankly, once again, it doesn't really matter what I think about whether they are or that they aren't guilty.
No.
So it's just a matter there of giving that advice. And, some people may struggle with that. Fine, if that's the case, well, the criminal bar's not for you. Go into a different area of law, and that's no problem at all. Mm-hmm. But, as long as you're happy, you can do that, you can sleep at night. Well,
at the end of the day, everyone is entitled to a fair trial. And to put their case, and if they've told you this is my case, you're just representing them. It's quite simple, really.
Yeah. So to answer the question, when people say, "How do you defend someone who's guilty?" or is guilty, the reality is you don't.
Yeah.
Okay. As a general rule, you'd be professionally embarrassed, so you wouldn't.
Yeah. It's not like the films and the movies where you're representing like the mob family and they're like secretly blackmailing you or. They're paying you millions behind the scenes, and you're going around intimidating witnesses, and no, it's not like
your
that.
suits where they're redating documents and all that.
Yeah, oh my gosh, yeah. Yeah. The reality is, barristers uphold the rule of law, and their duty is to the court, and they cannot mislead the court.
Yeah, contrary to the stereotypes, we're a pretty honest bunch, us lawyers, believe it or not.
We promise. There we go. That's another myth.
Yeah, another myth dispelled. Debunked, sorry.
Yeah. So if there's any other myths that you think, or any other preconceptions you have, tell us, and we will tell you if they're true or not. But there's a few on this list that I can think of, so we'll keep this going as a little segment for the next couple of weeks.
Sounds good to me.
So moving on now to the Advocacy Club.
Okay.
So we've got 2 sessions coming up this month. The first is tomorrow. Yeah. And this is our debating session. Mm-hmm. So I thought, John, do you want to just give... we're over half an hour in, so we won't turn this into a huge segment, which I know we could. Yeah. But you just gave 3 top tips for debating. Nice and simple.
Okay, number 1, have some structure. Okay, so think about it. And, it doesn't need to be a groundbreaking structure, but... quite often, you can see people go in and just start raising points off the cuff, and it becomes an argument without flow. So make sure you've got structure. So even if it's just having a bit of a basic introduction, I'm going to argue that so it's fireworks this week, isn't it? So let's say you're arguing in favour of fireworks being sold to the public. I'm going to argue in favour of fireworks being sold to the public. Simple line. Within my argument, my 3 points are X, Y, and Z. Quick one sentence just to set out what they are, and then deal with them one at a time, and then nice conclusion to sum up why you say what you say. Okay, so structure is key. It makes you seem clear, it makes you seem logical, and it gives your argument some flow. Number 2, speak slowly. Yeah. I talk about this a lot in relation to public speaking, and speaking slowly keeps you calm, keeps you focused, and someone who speaks slower appears more confident. When you speak super quickly, as I do on this podcast sometimes we get a bit excited with ourselves. Sometimes we get a bit excited, but speaking quickly can make you seem flustered, make you seem confused. You can trip over your words, and then when you trip over your words and you have to repeat something, it loses its impact. So speaking slowly adds an air of authority to what it is that you're saying. And that leads me on to point 3, which is if you've got some way of backing up what you're saying. You know, we're lawyers. When you're at law school, when you're doing an essay or what have you, you're going to make a point, you'll back it up with authority. If you're in a moot and you make a point, you back it up with authority. If you've got something to back up what you're saying, you know, so you might make it, you know, it could be a non-legal argument like this one.
Mm-hmm.
So, you know, it might be there's an empirical piece of research that's been done about why it is great to sell them to the public or why it isn't. Throw that in. You might have some statistics about, you know, injuries that people have caused themselves through buying fireworks, you know, whatever it might be. If you've got something to back up your point, it makes it seem much more authoritative and gives the point much more strength. So yeah, so 3 simple tips, which is structure, speak slowly, back your points up.
There we go. So for everyone joining us tomorrow online at 7:30 p.m, hope those tips were helpful.
Hopefully.
And if you're not a member yet, you want to join, there's still time.
There's still time.
You can join whenever you want, any point in the month. New members are welcome. So you'll be listening to this on Friday or afterwards. So you might be in time for the civil submission session, which is on the 29th of October.
Yeah.
Or our future months, which, you know, we've just released our timetable all the way till December 2025.
We have.
So we've got a good mix of advocacy and public speaking training for you in all these sessions. So it's a really exciting 14 months that we've laid out for you.
It really is. And I think we've done it quite nicely. So we've got a new edition next year, which is family law. All of our other classic sessions will be back as well. And on top of that, the way we've structured next year's timetable is that in the lead up to each of our competitions, there are Advocacy Club sessions on that particular form of advocacy.
Yep.
So, for example, in the lead up to a bail application, we've got a bail application session, etc., etc. So it gives people the opportunity to practice before competitions. Mm-hmm. So we've structured the club quite nicely for next year. Thought really carefully about the calendar.
Yeah. It's so exciting to think we've mapped it out till December 2025 already.
It's mad to think that that's going to be year 5 of the club.
You forget, don't you? When I think about it, I think it's been going for about 2 years.
So do I.
And then you're like, oh God, no.
And it makes you think, like, how long ago must that walk have been? Because obviously I came up with the idea on a walk.
On a COVID walk?
Yeah.
Or was it? No, it was COVID.
Yeah, it was a walk during COVID.
It was during COVID,
yeah. So it would have been some point during 2020. And once again, just like most things that we do here, just said, you know what, let's give it a go. Let's make a page on the website. Let's make an advocacy club.
We know how to execute an idea here at Speed Mooting, don't we?
We do. It's one thing we've learned. Give it a go.
At the end of it, and if it it might not have worked, but who cares? You haven't lost anything.
No.
We went to a Stephen Bartlett concert, didn't we? And he said he has a team of people, and all the he calls them. What does he call them? It's like a failure.
Yeah, like the failures division or something like that, isn't it?
But literally all they do is just try new ideas, and he says 99% of them fail, and that's fine because 1% of them work.
Yeah.
And never be scared of failure. It's just
give something a go, and it applies for you guys who are trying to break into this profession.
Mm-hmm.
You see an opportunity. A volunteering opportunity, an opportunity for a new job, whatever. Do I apply? Don't I? Just go for it.
Yeah.
Just go for it.
Yeah.
What's the worst that can happen? Nothing.
There we go. So, so that's our debating session coming up tomorrow. And then, as we touched on the 29th, we've got our civil submission session.
We certainly have.
So, in readiness for this, we made a really useful post, and we sent this out to our mailing list as well. So they've got a PDF version. So this was a very simple guide of all the steps involved in a civil claim.
Yeah.
So again, that was a very condensed, bite-sized version of each step. So I thought over the next few weeks we can break them down a little bit further.
Sounds good, yeah, let's do it.
So I think we said this at the beginning of the podcast, but we'll just recap again. So when I was in private practice, I was a property litigator. Mm-hmm. So my practice was embedded in civil litigation. Although John is a criminal barrister, he's also dabbled himself in the civil world.
I did civil lit for 3 years, so indeed. I know a little bit.
You know a little bit about it, and you've even had to do the handful of civil cases, haven't you?
Yeah.
So, yeah, helped a friend out.
Keep my hand in, yeah. A friend of mine, he's a commercial solicitor. And we were after dinner and he went, fancy doing an allocation hearing tomorrow? Yeah, I was already in court doing other bits and bobs. I said, yeah, I'll squeeze it in, why not, yeah?
Yeah.
So I've done a few bits and bobs of commercial law even.
Yep.
So it must have been weird for that judge seeing a criminal barrister pop into his court.
Yeah. So what we'll do today, we'll just very quickly outline all of the steps, and then week on week we can break them down further for people. So first step, John, is pre-action.
Yeah.
So what this means in a nutshell, all civil claims are dictated by our civil procedure rules. Mm-hmm. So these, like the criminal barristers, these are our rules, these are our conducts that you have to follow. If you don't follow them, there are ramifications, things like adverse cost orders, or you can even have your whole claim struck out if you don't follow these rules. Yeah. Within civil litigation itself, there's a magnitude of different types of civil claims. So John, the civil that you dabbled in was road traffic
stuff and just general personal injury.
Road traffic, personal injury, so there's those types, there's property types, there's debt types, there's all different types.
Yeah.
So I think in total there's 13 pre-action protocols. So your first point of call is to find the pre-action protocol that applies to you.
Yeah.
But in general terms, all of the protocols are similar in the sense that they dictate the steps that a potential claimant has to follow before they issue a claim.
Right.
If they don't follow it, they're going to get themselves into trouble.
Yeah.
So it's typically things like you have to send the potential defendant a letter before action, you have to set out your claim, you have to disclose what evidence you have, you have to try and engage in ADR, so alternative dispute resolution, before you issue a claim.
Okay.
So the whole purpose of this really is to assist the court, not to litigate if you don't have to, and to make sure that you've given this potential defendant the opportunity to reply before you go straight to issuing proceedings. Yeah. So there was a recent case, it's the Churchill case. This case proved that the court can force parties to engage in ADR basically, but it doesn't mean everyone is going to be forced to do it. It's a case-by-case basis, and it shows that the court can utilise their powers that way. So for any civil litigators, it's a stark warning to tell your clients, if you're ignoring ADR, potentially you're going to find yourself in trouble.
Yeah.
So that's pre-action. Next step is issuing the claim. So pretty straightforward, really. You send a claim form off to the court, they seal it, you have to serve the defendant with that alongside your particulars of claim in most cases. Yeah. Defendant has 14 days to apply and another 14 days to defend. Yeah. So that's issuing the claim. So the next step, which is the step that John has dabbled in recently, is track allocation. So again, we'll break this down because this is a mammoth topic in and of itself, but essentially there are 4 tracks. There used to be 3 up until October 2023.
Yeah.
They introduced the new track, so there are now 4.
That was news to me as well.
Yeah. Based on the value of your claim and the complexity of your claim, the court will allocate your case into one of 4 tracks. Small claims tracks for the really simple cases, usually £10,000 or less. Yeah. And typically it's litigants in person can deal with their own cases in these tracks. So nice and simple. Then we have the fast track, which is usually 10,000 to 25,000. Trials that can be dealt with 1 day or less. Right. The intermediate track, which is the newer track, which is for claims up to 100,000 typically. And basically this new track means that cost recovery, you can only recover fixed amount of costs. Right. That's what the new track is essentially trying to do. Bring in more fixed recoverable costs for people. Right. And then the big track, the multi-track. So this is usually where people want their claim to go.
Of course it
because cost recovery. So complex cases where expert evidence is needed, where there's lots of witnesses, where the trial can run for a week, where the claim is valued over £100,000. These are all the type of things that will get your claim into the multi-track.
Yeah.
Quite often, we will try to get, if something, doesn't quite hit the threshold, we'll try to convince the court, for one reason or another, it should still go to the multi-track. Usually the complexity of the case, the number of witnesses, etc. So this is what you've dabbled in, haven't you?
Yeah, that's exactly what I was doing. So I think it was a small claims case that they were trying to get into the fast track. So they're trying to say, even though the case isn't 10k, it's a complex area of law, there might be an expert witness involved.
Yeah.
So yes, that's exactly what we were trying on that case.
I think generally it's quite hard to convince the court to go outside the general rules of what fits into what track.
Yeah.
Because obviously the tracks are there for a reason. They like to streamline the cases in whichever track they're supposed to be in. So you don't see much success, I don't think, with trying to convince the court to get your case into a different track. But sometimes you do.
Sometimes it can work, yeah, and sometimes it's it's justified.
Of course, it's always justified, isn't it? Or you'd think otherwise.
Well,
it's not. Remember, as lawyers, we're very honest.
Yeah, no, that's what I mean. So when they're granted, so I should qualify that. I wasn't going in making fanciful arguments. The arguments that we made were legitimate for transferring the claim from one track to another, despite the financial value of the claim.
Yeah, definitely. Otherwise, we wouldn't do it. We wouldn't advise our clients to waste costs trying to do it. So yeah, that's track allocation. Next step is directions.
Yeah.
So this is basically a set of things that the claimant and defendant have to do in the build up to trial, and it's all aimed at making sure all the T's are crossed and the I's are dotted.
Yeah, I always get that one the wrong way around.
You have to think about it, don't you? On the day of trial. A lot of the time as well, it leads to settlement because it's things like disclosure, so stuff that wasn't given for pre-action or stuff that's come to light now. You're handing everything over. This is the point when us lawyers will go through the evidence and think, oh, we should probably settle.
Yeah.
Because your prospects have dropped, etc. And also, it's just a lot cheaper to settle. No one wants to get to trial because it's so damn expensive. So yeah, it's things like disclosure of evidence, exchanging your witness statements. If there's any expert reports, they have to be exchanged, etc., etc. So there's a list of directions usually. Depending on what track you're in as well, the directions might be more in depth. There might be more of them. So a multi-track, for example, there can be a 3-page court order of directions.
Yeah.
Small claims, 1 or 2.
Yeah.
So that's directions. Then we have the trial, which is, as it says on the tin,
Trial.
It's a trial. This is where all the witnesses give their evidence and the judge will make a decision and find in favour of one party or the other.
Yeah.
And depending on how the trial goes, the winning party will be awarded costs sometimes. So again, this is a mammoth topic that we can talk about for a long time.
Oh yeah,
when we get to its segment.
More detail.
Absolutely, but generally, small claims, no costs. You can recover a couple of disbursements.
Yeah.
Fast track and the intermediate track, fixed recoverable costs. So set costs dictate what you can recover. Multi-track, losing party has to pay the winning party's costs as well as their own lawyer's costs. So it's like double whammy.
Yeah.
That's why we don't like going to trial if we can help it, and especially not if prospects are poor.
No.
Often when us lawyers go to counsel, like yourself, John, and ask for prospects before we go all the way to trial. In all my time in practice, less than 10 cases went to trial.
Yeah. So I did 3 years in PI stuff. So that's first year was first year I was working on that big Sonai case, which actually did go to trial. You can find...
We won't talk about that.
We won't talk about that one. The judgment is on Westlaw. And then, I spent a couple of years doing your ELPL, slippers and trippers, accidents at work, all that stuff. And during that time, 3 trials.
Yeah.
It's never saw it.
No, it's very, very rare. And it's, it's because people are doing what they're supposed to do. They're following the pre-action protocol, as I say. We're trying to settle all the way through a case, and the majority of times, we will settle, or we'll get prospects, and we get prospects before we issue as well.
Yeah.
Like 99% of the time, we know before letting our client delve into this what their prospects of success are at trial. But even when you think they're great, as I say, disclosure, someone's got a smoking gun and you find it halfway through and it unravels everything. But it's very, very rare, even if you've got a rock solid case, that you'll get all the way to trial. Because if the party that doesn't have the rock solid case makes you a really good settlement offer, you're going to take it rather than... there's no trial that I've ever been on as well where the cost to get into trial have been less than 50,000.
Right.
And that's generous.
Yeah. And I suppose also, even if you have got your rock solid case and you get an offer, you've got your Part 36 considerations, if I remember correctly.
Yeah. There's again, that's a mammoth topic in and of itself, but essentially there can be consequences if you get a really good settlement offer and you ignore it. Yeah.
So it's something we'll talk about in more detail. And I think the other thing, which maybe I can speak about a little bit, that you've not really covered, is the portal. Yeah. So you have. So obviously, I don't think you have a portal in.
No, not.
I can't imagine you do, because they're not really standard things. But in your RTA, and then during the latter days that I was doing that stuff, they introduced it for ELPL work as well. I should say ELPL stands for Employers' Liability and Public Liability. So there was a portal for that as well, basically a streamlined process for the litigation, where liability is admitted but quantum is disputed.
So we'll cover that one definitely.
Yep.
So just recapping the costs. So in multi-track, the losing party has to pay the winning party's costs. However, it's not that simple, because it's always subject to assessment from the court, and you bet your bottom dollar the loser will dispute your costs. As we said at the beginning, if you may win at trial, but then when it comes to assess the cost, the judge will say, well, you didn't quite follow pre-action there, didn't give them long enough to respond. The usual point is, if you've got all the way to trial and you haven't been penalised before then, they will penalise you when it comes to your cost recovery. So typically, very good cost recovery is 60%.
Oh, wow.
Yeah.
That low.
I mean, we do... Sometimes, I had a trial once and we got something like 91%. And it was like, wow, because that's amazing. And the main reason for it is because I was running most of the trial, so my costs were really low, and the supervising partner had a very, very light touch to this case because I just knew it so well. Yeah. So typically that's why the cost was so good, because a junior was...
Sounds almost as bad as the way... I've heard stories about the way these commercial firms bill their clients as well. So, they do their hourly billing, and then, they'll run up a bill the client at the end of the month, the quarter. So I did this many hours, I'm a grade A fee, and my fee is this, but you know what? I'm going to write off 20, 25, 30%. You're like, what's the point in doing all the hourly billing?
I know, it is crazy, but it is a practice.
I've said this so many times, but I reckon commercial firms could learn so much from firms that specialise in private motoring defence. Fixed fees, very simple, very straightforward. It's better for the client. The client knows from the outset exactly what they're paying, and they get, it's a standard service that everyone, it's a good service that, they're getting a good service, but you know exactly what you get, and you don't need to worry about, can I afford to pay my lawyer for an extra few hours, all the rest of it. Yeah. It's, and I think these commercial firms could learn so much. Yeah, and operate on a similar structure, but hey ho.
And I think, it happens a lot. I used to see it a lot, and I even used to do it myself as well sometimes. It's the pattern you get into with certain clients. So, at the end of the month, okay, your bill's 1,160. I'm going to write that down for you, so it's just 1,000. It's always a nice, neat figure, and you're always writing it down on yourself, it's crazy. Or, a real estate partner I used to work with, he was so good with his costs because he didn't think about it. He didn't self-edit anything. Every month he sent it to the client going, this is where we are. And if it was higher or lower, he would say it's higher, so I need to revise the estimate. Simple as. Sometimes, he would take a view with his clients that he's been working with for 30 plus years, and he'd say, well, it's gone up so much more than I thought it was going to, so I'm going to cover the overrun because I know I've got about 10 years worth of work from this client. I'm not going to upset them. But because he was so used to print out a report of all of the cases every month, and month on month on month, he'd send a cost bill to his clients to update them. And that's where you get yourself in trouble. If you're not that organised And it's easily done when you're overworked, which so many commercial solicitors are, and you think, God, I haven't updated them, I haven't given them an update of costs for a month, 2 months, 3 months, and then you look and you've overrun by £10,000 because they're like, well, why weren't you telling me you were overrunning?
Exactly.
That's when you write it down, and it's not a great pattern to be in.
No.
And as you say, when it's standard fixed fees, like it was for me when I used to do volume work as well, it was so much easier. So much, because it didn't really, you still had to record your time, but if you were under or over, it didn't matter. You billed what you said you were going to bill for that piece of work.
Exactly, and guess what? You know, your lawyers are under so much less pressure as well. You know, it's something you see all the time. You know, the big firms put so much pressure on their lawyers. You've got to bill this many hours, you know, 1,500 hours a year, 2,000, you know, whatever it is. Imagine if you've, as a lawyer, you've not got that pressure of having to bill all those hours. Guess what? You're a lot less stressed. You put a better performance in for the client. Clients like it. You get more referrals. I think if I ran a firm, I'd revolutionise it. I would absolutely clean up. It's.
I'm sure. There's more reasons behind the scenes why everyone hasn't switched over to that model yet. But I think it probably will end up there more often than not, just because of all the discussions right now about work-life balance and the strain and the pressure of it. It's, you know, it's a hot topic. It's being talked about a lot, and the billable hours model seems to be where most of the problems come from.
Of course it does. I mean, do you know what? I've been lucky that I don't think I've ever had to work in a single firm where I've needed to do time recording and stuff. You know?
You are very lucky.
So I've been pretty lucky in that regard.
Yeah, I would agree. Very, very lucky.
Yeah.
We all hate it.
Yeah.
We all hate it. There we go. Don't let that put you off from civil litigation. Because it's fun. Yeah, it's a really interesting, dynamic area of law. No 2 days are the same, and it covers a huge variety of disputes. So it's a great area to get involved in. I definitely loved my time in private practice.
I enjoyed civil litigation as well. So
not as much as I'm loving being a legal director of my own business, I did still enjoy it. Okay, so that is an overview of civil lit. A bit of a big overview, actually.
Yeah, we spoke.
As I say, but because there's so much involved, and we will break each section down for a segment going forward, because I know people like a bit of the civil as well. Yeah,
sounds good to me.
So before we finish, John, people, if anyone's watching this on camera, they're probably thinking, what on earth is John wearing?
So we've got, it says rock bottom cup, play outside the lines, and you've got like what kind of glass would you describe that as?
It's like a cocktail glass,
but
it's not got a drink in it.
It's not got a drink, it's got a tennis ball in it. And so this is so the rock bottom is nothing to do with the Rock's finishing move. Rock bottom! No, the rock bottom cup is held at the John Newcomb Tennis Ranch in New Braunfels, Texas. Mm-hmm. And it's an annual event, been going for 6 years now. So the next one's RBC 7. And that's their little motto, play outside the lines. Because it's a celebration of tennis, so it's like a 3-day sort of tournament. And Hayley, you're going for the first time next year, aren't you?
We're going to go in August, aren't we?
We're going to go in August.
Exciting.
And we get to do so many different things. There's a little bit of tennis there. Neither of us play tennis, so that's going to be interesting. You do a bit of kickball, a boat race, which doesn't involve a boat. And there's a river float. So you get to float the Guadalupe River, which is a good laugh.
So exciting. I've been hearing John talk about this for years.
Yeah.
You went, when we first got together, you went a few times since.
Yeah, so we went in 2019 to RBC 1. So they go for an international flavour. So me and my brother Alan were the only British people there. We had a few Mexicans there, and then the rest
Australians.
were all, Australians, and then Americans, and then even more of an international flavour every year going forward. So it's been really good. So you get to meet cool people from all over the world.
Yeah. We'll do loads of vlogging when we're there.
Yeah, 100%. We will do. And I mean, to be fair, the guy who runs it, so there's 3 or 4 founders, and they've all got podcasts as well. So we might do some collab podcasts. So you might see some international people talking about tennis on the podcast. I know it's not law, but hey ho.
It's all good fun. We can have a little segment.
Yeah, we might as well have some good segments up there. So that'll be interesting.
Certainly will. Right, we're over an hour long now, and
Yeah.
poor old me's got to go and edit this. So should we call it a day?
Let's call it a day. So I've enjoyed recording the podcast. Hayley, have you enjoyed recording it?
I certainly have, John.
I hope you've enjoyed listening, and if you are still listening at this point, pop a comment, rock bottom.
Oh, okay.
What were you gonna go
I was
for?
going to say tennis, but rock bottom.
Rock bottom. So yeah, that brings us to the end. Hope you enjoy. See you next time.
Bye.